most part, Judge, I'm just going to rely on that pleading, but what's important in this case, for purposes of arguing the Lattimore standard and the required finding, is that in the facts and circumstances of this case, even if you consider all of the evidence in the light most favorable to the Commonwealth, that the circumstantial evidence and the inferences have not been proven on the elements of premeditation and intent. And it's important to distinguish the fact that where inferences can be reasonable when they have to do with other factual issues that do not constitute the specific elements of the crime charged, here the inference must be beyond a reasonable doubt because it must support the element of premeditated murder, and it must support the specific intent to kill. And whereas the Commonwealth has based their whole prosecution on what we characterize as a three-pronged approach, that motive evidence that they theorize supports an inference of intent and premeditation, they have failed to present the type of quantity and quality of evidence that would then result in an inference beyond a reasonable doubt that Mr. Walshe ever premeditated a murder or ever manifested the specific intent to kill. The three-prong approach that the Commonwealth took in this case was that Mr. Walshe was motivated by financial interest, which has not been established by any inference sufficient to carry the day, even on the Lattimore standard. The second prong is that somehow Mr. Walshe was using his children and his role as primary care provider to avoid going to prison, and that has not been established by any sufficient evidence. And then there's the third prong, and it has to do with the affair, and where it seems clear that the Commonwealth has established that Ana Walshe did in fact engage in an intimate affair with William Fastow. They have failed to establish sufficiently to withstand the Lattimore standard that he even knew about the affair. In fact, if you consider the evidence in the light most favorable to the Commonwealth from their own witnesses, there is no evidence presented to this jury that he knew about the affair, that he reacted to any knowledge of the affair. And in fact, the reaction that he had fell far short of someone that was even jealous of the fact that Miss Walshe reported to him specifically that she had a crush on Mr. Fastow. And I understand, we understand, that whereas motive is not an element, that's not what we're arguing. And I say in our motion that if the government stands up and says since motive is not an element, that the argument that we just made doesn't apply. Well, that misses the point, because that is the whole foundation of their prosecution in this case. And so respectfully, Judge, in the unusual circumstances and the complex circumstances presented in this case, I would ask that a required finding be entered on indictment 001.
Thank you.
Thank you, Your Honor. Viewed in the light most favorable to the Commonwealth, the evidence is sufficient for a jury to find the defendant guilty of the premeditated murder of Ana Walshe. Your Honor, as to evidence that the defendant killed Ana Walshe, the defendant was the only adult in the house on January 1st after Mr. Mutlu left. There's evidence before the court that Ana was a fit and active 39-year-old, and in fact that she participated in a vigorous exercise class at Bar Method on the 31st of December, where she demonstrated that she was in good physical condition. Evidence of the bloody slippers, bloody bath towels, bloody carpet, on his broken Gucci necklace, combined with the defendant's internet searches about cleaning blood from wood floors, his purchase of large quantities of cleaning products, are sufficient for the jury to find that Ana met a violent death in the living quarters of 516 Chief Justice Cushing Highway. I'd also point out there was a cut on the defendant's thumb, and there was evidence that he did purchase Band-Aids and some antibiotic cream on January 1st. As to deliberate premeditations, there's evidence that the defendant was aware of Ana's relationship with another man. He told police that he monitored the Chase credit card statement. That is an evidence before the court. That statement includes a purchase of a plane ticket to Dublin in over the Thanksgiving holiday in 2022. The defendant was aware of Ana's itinerary. He told police that he had suggested that she go out during a layover in Frankfurt, which she did have a layover in Frankfurt at one point of that travel. And again, looking at that travel, it's clear that looking at the Chase statement that it was indicated a trip to Dublin. And the defendant told police that she had only gone to Serbia to see her mother. And I suggest the evidence is more than sufficient to find that he was aware of that trip to Dublin. He also searched Will Fastow's name on December 25th, and he also researched emergencies in buildings that Ana managed in D.C. I'd also point out that the defendant's phone, which he said was mislaid from December 31st to January 2nd, he told Mr. Mutlu that when Mr. Mutlu came for the New Year's Eve dinner. That phone was repeatedly unlocked and connected to a power source while it was supposedly missing. The evidence indicates that the defendant used that phone to create an alibi for himself. It explains why he was not contacting Ana. And then when he did say he recovered the phone, he started sending text messages to Ana, and he later showed those messages to police. It suggests he was using the missing phone as a way to create an alibi for himself. And to explain why there was he didn't have the phone with him when he went to Vin and Liquors and threw something into the dumpster, or when he was in Lowe's buying cleaning supplies and cutting tools on January 1st. Your Honor, there's also ample evidence of motive. There's evidence that the jury can find that if Ana took the children to D.C., the possibility of the defendant avoiding jail time on the federal charges would lessen. We heard testimony today about the impact of that on Ana and what she intended to do. Ana also had life insurance policies and financial accounts, which the defendant was the named beneficiary, and he stood to inherit substantial funds if Ana Walshe were deceased. And also, Your Honor, the defendant's elaborate web of lies regarding Ana allegedly leaving for a work emergency in D.C. He lied to friends, family, and the police about that. I suggest that that also is sufficient evidence to give this case to the jury, and would ask that you deny that motion for required finding of not guilty.
All right. The Latimer standard dictates that I take every inference, all the evidence and all the reasonable inferences from that evidence in the light most favorable to the Commonwealth. Adopting that standard, I'm not convinced by the defendant's motion. I'm not going to repeat the evidence that the Commonwealth has just, in brief, summarized for the court. That evidence that this jury has heard and seen is adequate to allow the jury to deliberate the case, in that, again, drawing all the inferences, reasonable inferences from the evidence that's before this jury, there is sufficient evidence for this case to go to the jury for them to determine the three elements that are before them. But it gets over the Latimer standard. So the defendant's motion is denied.
We would just object to the record.
I understand. You indicated to me at the side of the bench that there were some evidentiary issues you wanted to address with me.
There are. Can we go to the sidebar for these, Your Honor?
Yes, you may. All right. So I think that we all have our tasks for the evening, and I'll see you back tomorrow. Anybody need anything? All right. Thank you very much, everyone.
Thank you, Your Honor.